Today, the Supreme Court issued a unanimous decision, a 9-0 decision, which significantly constrained the EPA's authority as an executive agency, but also this decision sends a clear and huge signal to all other agencies like the ATF that their current overreach is at an end. So let's talk about this. Now, before we jump into this video, I actually have an announcement for you guys. Next Tuesday, this upcoming Tuesday of when I'm posting this video, which is May 30th, I'm actually doing an event down in Huntington Beach here in California. I'm going to be doing it with Rifle Supply. It's just going to be a quick pop-up event. You guys can come out, hang out with us. They're doing some deals. Maybe we'll do some giveaways, things like that. And then also we are doing a live podcast there. I'm going to be there pretty much all day. And if you guys want, you can come through, ask questions, meet, hang out, do all that stuff. So it would be really cool to meet a lot of you guys. So I just want to make you aware of that. Next week, May 30th at Rifle Supply in Huntington Beach, we will be doing a quick event. Now, like I mentioned in the intro, in this video, we're going to be talking about a unanimous decision by the Supreme Court that they just issued. This case is called Sackett v. EPA, and although it does not deal directly with the Second Amendment, it will have significant impacts on future two-way cases and also currently what the ATF is doing as far as their overreach. Also, this decision signals that the Supreme Court is on a very active quest to constrain the executive agencies and their current overreach, and it really just signals what's coming up for agencies like the ATF who are engaging in these similar type of actions. Now, the facts around this case are as follows. In 2007, the Sacketts, a couple, began building a home in a residential lot near Priest Lake, Idaho. The couple obtained local building permits and started placing sand and gravel in the lot where they were going to build that house, but then they got an order from the EPA to essentially stop their work, and they were also directed to restore the property back to its natural state. The EPA claimed that the land where the house was being built contained wetlands, which was protected under the Clean Water Act. If the couple did not comply with the EPA's directions, they faced around $60,000 in fines per day and potentially severe criminal penalties. And really, this entire case in battle can be summarized as the EPA is claiming that this piece of land that the couple was trying to build their home on was in fact wetlands. They're claiming that this area is wetlands, and therefore it falls under the Clean Water Act, which protects the waters of the United States and prevents them from essentially building there. The couple, in contrast, claims that this property cannot meet the definition of waters of the United States as defined in the Clean Water Act. The Sacketts sued, alleging that their property was not waters of the United States as defined in the CWA, and therefore the EPA did not have the authority over their ability to build on this piece of property. Now, on review, a district court entered summary judgment in favor of the EPA. They found that this was wetlands and was covered under the CWA. The Ninth Circuit then reviewed the case and affirmed the ruling of the district court. This case then made its way up to the Supreme Court for review. And today we received an interesting unanimous decision, a 9-0 decision by the Supreme Court reversing the Ninth Circuit's decision. Now, although all the judges agreed in the judgment of reversing the Ninth Circuit's decision, there were varying concurrences, varying rationales, ultimately of how all these justices, how all the judges on the Supreme Court came to their determination. Joining Justice Alito in his majority opinion were Justice Roberts, Thomas, Gorsuch, and Amy Coney Barrett. Justice Kavanaugh wrote a concurrence in which Justice Sotomayor, Kagan, and Jackson concurred, and then also Kagan, Sotomayor, and Jackson wrote their own concurrence as well. But they all came to the same determination ultimately that the Ninth Circuit's decision needed to be reversed, but they came to it at different kind of analysis approaches. In the majority opinion authored by Justice Alito, the court found that the agency's interpretation of wetlands in this case is inconsistent with the statute's text and structure, and the law extends only to wetlands with a continuous surface connection to bodies of water that are waters of the United States in their own right. Justice Alito, in his opinion, stated that to assert jurisdiction over an adjacent wetland under the CWA, a party must establish first that the adjacent body of water constitutes waters of the United States, i.e., a relatively permanent body of water connected to traditionally interstate navigable waters, and second, that the wetland has a continuous surface connection with the water, making it difficult to determine where the water ends and where the wetland begins. So here, the majority of the Supreme Court is rejecting the idea that just because a piece of property has some water on it and it's adjacent to a different body of water, that doesn't mean that it's covered under the CWA and that it's waters of the United States. Instead, they claim that the wetland needs to be continuously connected with a larger body of water that is clearly a water of the United States as covered by the CWA. But important for the ATF's current actions and their Second Amendment violations is this statement by Justice Alito and the majority. They stated, "The EPA asked this court to defer to its most recent rule, but for multiple reasons, the EPA's position lacks merit." They go on to state that the court has required a clear statement from Congress when determining the scope of the waters of the United States. Second, the EPA's interpretation gives rise to serious vagueness concerns in light of the CWA's criminal penalties, thus implicating the due process requirement that penal statutes be defined with sufficient definitiveness that ordinary people can understand what conduct is prohibited. Where penal statutes could sweep broadly enough to render criminal a host of what might otherwise be considered ordinary activities, the court has been wary about going beyond what Congress certainly intended the statute to cover. Under these two principles, the judicial task when interpreting the waters of the United States is to ascertain whether clear congressional authorization exists for the EPA's claimed power. And on review, the Supreme Court found that the statutory language did not include the property in question, and that even the vagueness of the language and the criminal implications means that the EPA only has authority over things that Congress clearly included in that statute. If this sounds interesting and important for the ATF context, that is because it is. The ATF claims, like the EPA, that they have broad authority to regulate various things because statutory language allegedly gives them that power. The ATF often bends the statutory language in the NFA and the GCA essentially to their will, and then they impose their interpretation against people and items despite the criminal implications. For example, just look at their recent interpretation and rules in regards to pistol braces, bump stocks, and 80%ers. But in this decision by the Supreme Court states that that claimed agency authority under statutes needs to be clearly authorized by Congress. And that really applies especially when an agency is broadly interpreting a statute in that language, which would cause the statute to become vague and then impose serious criminal penalties. So this is important for the ATF context because we are seeing further chipping away of agencies being able to just interpret statutes however they want, claim these broad authorities, and the ability to regulate essentially whatever they want. Also, Justice Thomas and Gorsuch, in their concurrence, they also attacked the use of the Commerce Clause, and they said that the current use of the Commerce Clause goes beyond what the founders would have ever intended. So here the Supreme Court is firmly saying that water is water, land is land, despite what the ATF wants to claim. And hopefully soon we can get the Supreme Court to take up a case where they say firearms are firearms, SBRs are SBRs, machine guns are machine guns, suppressors are suppressors, guns are guns, rifles are rifles, and that the ATF's broad interpretation of those various terms to include other items which were never intended just is not permissible at all, and therefore they strike down those types of actions by an agency like the ATF. So again, really interesting. We are now seeing a bunch of cases stack up which are limiting executive agency authority, specifically to the EPA, but we have a ton of other cases that are currently trying to work their way up the Supreme Court. We have cases like the Cargill bump stock case, which are seeking Supreme Court review, that even the ATF is pushing for Supreme Court review. And then also, like I mentioned, you have that Loper case, which deals with whether or not Chevron deference will be struck down or whether or not it will be greatly limited. So really interesting. We're seeing some very interesting development at the Supreme Court level. And if you guys have any questions, go ahead and comment down below and I can try to answer to the best of my ability. Also, if you want to learn more about what's going on in the two-way world, you can watch these videos here on the screen. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.